welcome to our lecture. And it's a great pleasure to introduce our lecturer today. The Revd Dr Becket Soule OP has taught classical languages, law and history at the Catholic University of America, the Dominican House of Studies in Washington, D.C., the Pontifical College Josephinum in Columbus, Ohio, and Oxford University. And he retired as Professor of Canon Law at St. Paul's University in Ottawa, Ontario, where he still continues to teach and supervise doctoral studies. He has been visiting lecturer and fellow at other institutions of higher studies in the US, Great Britain, and Ukraine, and has served as an official of the Congregation for the Eastern Churches in Rome, and as judicial vicar and episcopal vicar of the personal ordinariate of the Chair of St. Peter in the United States and Canada. Becket has also served several Anglican and Catholic parishes and is now pastor of St. Margaret of Scotland Catholic Church in Maggie Valley, North Carolina. And he is, of course, going to speak today on the recognition of orders by the Roman Catholic Church. Becket, it's very good indeed to welcome you to this virtual ELS lecture, and we greatly look forward to hearing what you have to say to us. Thank you.
Oh, thank you. It's really great to be here, and let me share my screen. And so I hope that is now visible to everybody. I am not going to be talking very much about theology. Clearly, there are significant theological foundations and background to all of this, but my principal attention is going to be paid to the historical and the canonical processes that are used in the recognition of orders by the Catholic Church. And I'm also going to make a brief excursus to review the process by which another Western church, the Protestant Episcopal Church in the United States of America, now called the Episcopal Church, how that church distinguishes between those churches which are in apostolic or historic succession and those which are not, and how it handles the reception of clergy and congregations from the Catholic Church. Let's see if I there we go. The Union of Brest is the first of these opportunities. The Union of Brest was announced by Clement VII's bull, Magnus Dominus, of the 23rd of December, 1595. And in the following few months, the rights and privileges of the clergy of the Ruthenian Church were worked out and published in the bull Decet Romanus Pontificem on the 23rd of February in 1596. That bull provided for many of what I think we would call the nuts and bolts matters of the Union, and the Holy See made sure to receive the approval and guarantee of the Polish government for its provisions, particularly senatorial seats for bishops, financial aid for the clergy and the churches, and the security of church property. Of particular interest, however, were the ecclesiastical provisions of this bull with regard to two sacraments, which were treated analogously. Both marriages and ordinations were sanated. Sanatio in radice, literally healing at the root, is the exercise of executive power of governance in order to supply, in certain circumstances, formalities or actions that were missing in an original juridical action, and without which the juridical action would be invalid. It's not restricted to the convalidation of invalid marriages. It extends to all areas that fall under the positive law of the Church. It's thus possible to sanate For example, invalid professions in a religious institute, invalid reception into a confraternity. Furthermore, the invalid erection of religious institutes, the invalid erection of the Stations of the Cross, the invalid alienation of church property, and invalid juridical sentences can all be rendered valid by the effects of a radical sanation. This form of sanation represents the most ancient form of dispensation, namely a post factum dispensation. Prior to the Council of Trent, the procedure was used principally in marriages and in the legitimation of children, ad temporalia, and almost always applied in individual cases. Sanation in that precise language didn't exist in Roman law, but in some cases, a marriage automatically became valid when an impediment ceased, provided that the parties were still cohabiting as man and wife. That was the case when marriage had been attempted before the parties reached the required age, and the convalidation became effective as soon as they attained that minimum age. And this is all found in book 23 of the Digest of Justinian. Sanation in some ways was analogous to a retroactive dispensation, and it's still used in that way. Radical sanation of marriage is granted only after a marriage has been invalidly contracted. Its very nature excludes its use prior to marriage. That's to say, it's never granted in order to contract marriage. By the middle of the 16th century, however, the papacy had begun to use sanation for entire classes of people. A general sanation was issued by Julius III through his legate, Reginald Cardinal Pole, in 1554, in reconciling the Church of England. Sanation remains an important procedure in marriage, where it's the convalidation of a previously invalid marriage without a new exchange of consent. And in proceeding in that matter to the convalidation of the union through a radical sanation, the Church departs from the usual mode of convalidation and doesn't require the parties, or at least one of the parties, to renew matrimonial consent. In the place of this customary renewal of consent, the Church accepts the consent originally given as sufficient to constitute a valid marriage when the invalidating impediment has been removed or a dispensation from the required form has been given. It's thus the first consent that is being rendered juridically effective through a fiction of the law by which the Church draws the dispensation back to the beginning of the union or to some intermediate point and heals the marriage from the root. Joannes Andreae referred to it as a fictio juris, a legal fiction. But canonists of the later Middle Ages and since have viewed it as a way of preserving true marital consent in the face of a dispensable marriage impediment or of a defect or lack of canonical form. It's a significant instrument of pastoral care. The decree Temetsi of the Council of Trent in 1563 had introduced the institute of canonical form, or marriage before the party's proper pastor and two witnesses, and declared all other marriages invalid in those areas where the decree was promulgated. And while the original purpose of the decree was to reduce the number of clandestine marriages, it was extended to a variety of circumstances unintended by the original decree, and it became relevant in the case of the Union of Brest, since thousands of marriages had taken place without the presence of the proper, namely the Catholic pastor, prior to 1595. And these marriages were now all deemed valid. The sanation of ordinations, however, was an innovation. Here, the ordinations of non-Catholic clergy who were coming into full communion with the Roman See were regularized without undergoing another ordination. And while in the modern context, it's clear and has been explicitly stated that the Catholic Church recognizes the validity of ordinations conferred in some non-Catholic churches, particularly the Eastern churches, and thus the sacrament of baptism, confirmation, or ordination validly conferred outside of the Catholic Church need not be repeated. This statement was not as clear in the 16th century, in which the anathematization of non-Catholic bodies, both Eastern and Western, left in doubt the state of their clergy and their ability to exercise their power of orders once they had entered into full communion with the Catholic Church. Clement VIII wrote in Magnus Dominus that prior to the union, the bishops and all members of their church were not members of the body of Christ, which is the church, because they had no ties with its visible head, the Supreme Roman Pontiff. And for that reason, he had to absolve them from all excommunications, suspensions, and sentences of interdict, censure, and penances. Some official statement of recognition was clearly required, but such a large influx had no obvious precedent. Without explicitly referencing the matrimonial sanation of Julius III, the institution of sanation was seized upon as the most appropriate and, in fact, the easiest way to regularize ordinations conferred outside of the Catholic Church and to permit those who were ordained to exercise their power of orders within a church operating under a different legal system. The provisions of the Union of Brest, with alterations having to do with the different political situations, were expanded to the eparchies of Užhorod in 1646, Peremisl in 1692, Lviv in 1700, and Lutsk in 1702. To paraphrase Gibbon, it was the aim of the Union of Brest in 1596 to disguise, and the object of Apostolicae Curiae in 1896 to reveal and exploit the divisions of the Church. My purpose here is not to review the theological contentions, but the canonical and historical considerations that shed light on the process of the recognition of orders. The publication of the documents of the Preparatory Commission for the Apostolic Letter, Apostolicae Curiae, the 2 volumes from the fontes of the archives of the Holy Roman Office, were published in 1997 and 2012. And this has revealed a wide-ranging discussion prior to the promulgation of Apostolicae Curiae. And then ARC-USA in 1986 issued a report entitled Anglican Orders, a report on the evolving context for their evaluation in the Roman Catholic Church, which provides valuable historical context, particularly with regard to the process by which the letter was produced, the political background and interventions resulting in the Preparatory Commission's work being overturned, and the new context that arose not long after the 1897 promulgation, bringing into question whether the conclusions reached by Apostolicae Curiae are of anything other than historical interest. The historical background upon which the commission studying the question of Anglican orders relied was spotty and ambiguous. At the time of the reconciliation of the Church in England upon the accession of Queen Mary in 1555, there were some reordinations. The reordinations were for both those who were ordained in the Sarum Rite and those who were ordained with the Edwardian Ordinal. And there were but these were only a small percentage of those ordained in either case, either under the Sarum Rite or under the Edwardian Ordinal. The main questions on which the apostolic letter turned were form and intention. The canonist who was assigned responsibility for presenting the position about the issue of intention was the young Italian priest working as the head of the canon law faculty of the Catholic University of Paris, Pietro Gaspari. Later on to become the father of the 1917 Code of Canon Law and one of the chief negotiators of the 1929 Lateran Treaty, which solved the Roman question. Gaspari pointed out, following the writings of the earlier Jesuit theologian Juan de Lugo, who lived from 1583 to 1660, that since neither the formula for ordination, either before or after the Edwardian Ordinal of 1550, nor any other text of the Edwardian Ordinal contained a statement about what was intended, it had to be assumed that the bishops had, at a minimum, the intention of conferring valid orders as instituted by Christ. In Lugo's parlance, they had intended to do what the Church does, and measured by that criterion, their intention should not be treated as defective. Herbert Cardinal Vaughan, the Catholic Archbishop of Westminster, however, became horrified by what he felt would be the disastrous consequences for the Catholic Church in Great Britain if Anglican orders were found to be valid, and he waged a vigorous and at times ruthless campaign, eventually resulting in the famous declaration of Leo XIII that Anglican orders were absolutely null and utterly void, a declaration without parallel. The formulas of ordination the Pope declared were defective in their statement of the sacerdotal function of sacrifice. From the use of the formulas of ordination, an intention not to do what the Church does was to be inferred from the absence of an explicit mention of sacrifice. The rite conferring the sacrament was used by the Pope not just as a theological index of belief, but as an expression of the personal intention of those purporting to confer it. The previous presumption of an implicit and predominating intent to do what the Church does was supplanted by a hermeneutic of hostility, of presuming an intent nowhere stated in the formulas, contrary to what the Church does. The choice of evidence, the forming of the presumption, appeared to reflect not a clarification of an implicit intention, but rather an a priori policy judgment that Anglican orders must not be recognized. As an aside, if that same process were applied to, for example, marriages of non-Catholics who are members of churches and communities where remarriage after divorce is permitted, and it was concluded that all of those marriages were absolutely null and utterly void, then matrimonial jurisprudence in the Catholic Church would be significantly different than it now is. Frederick Temple, the Archbishop of Canterbury, and William McLagan, the Archbishop of York, answered Pope Leo's charges in their written response. Saepius Officio, the answer of the Archbishops of Canterbury and York to the Bull Apostolica Curae. It was written to prove the sufficiency of the form and intention used in the Anglican ordinal rites since the time of the English Reformation. According to this view, the required references to the sacrificial priesthood never existed in any ancient Catholic ordination liturgies, and also in certain current Eastern Rite ordination liturgies that the Roman Catholic Church considered valid. According to the archbishops, if the ordinations of the bishops and priests in the Anglican churches were invalid, then by exactly the same measure, so must the ordinations of clergy in the Roman Catholic and Orthodox churches be. They pointed out that the preface to the ordinal explicitly stated that no new type of orders were to be conferred, but were the continuation of the apostolic succession, and that priests and bishops ordained under the Edwardian ordinal were not, in fact, reordained when the realm was brought back to communion with the Holy See. Many were deprived of their livings, but that would have been unnecessary if they had not been clerics. A significant change that occurred following the promulgation of apostolic curae is the consistent use in all Anglican ordinals of a formula recognized as valid by the Catholic Church. The participation of Orthodox and Old Catholic bishops in the ordinations in the Anglican churches, such that all Anglican bishops can trace their consecratory pedigree to Orthodox or Old Catholic bishops within the last 125 years, and a shift in Roman Catholic theology within the last century from a concentration on texts and formulas to a consideration of the ecclesial reality of the different churches and communities. When several canons of the Code of Canon Law were revised and a new formula for making the profession of faith was promulgated by the apostolic letter Ad Tuendam Fidem by Pope John Paul II, an accompanying letter entitled A Doctrinal Commentary was issued by then Joseph Cardinal Ratzinger, the prefect of the Congregation for the Doctrine of the Faith, in 1998. Giving examples of doctrines set forth definitively by the magisterium of the Church regarding teaching on faith and morals, Cardinal Ratzinger added, with regard to those truths connected to revelation by historical necessity and which are to be held definitively, but are not able to be declared as divinely revealed, the following examples can be given: the legitimacy of the election of the Supreme Pontiff, or of the celebration of an ecumenical council, the canonization of saints, dogmatic facts, the declaration of Pope Leo XIII in the apostolic letter Apostolicae Curae on the invalidity of Anglican ordinations. It's not at all clear what exactly the teaching on faith and morals contained in Apostolicae Curae that must be held definitively is. What is Leo XIII's declaration? Is it the necessity of a particular form and intention for validity? Is it that appearances to the contrary notwithstanding, a positive invalidity must be maintained? What about the changed historical circumstances and the factual errors contained in the bull? It is also unusual, to say the least, that this declaration was placed on the same level as the canonization of saints and the legitimacy of the celebration of an ecumenical council. In 2017, Francesco Cardinal Coco Palmerio, at the time president of the Pontifical Council for Legislative Texts, questioned the opinion expressed in Apostolicae Curae. He said, when somebody is ordained in the Anglican Church and becomes a parish priest in a community, we cannot say that nothing has happened, that everything is invalid. He cited the fact that Pope Paul VI presented his episcopal ring, as well as a chalice, to Archbishop of Canterbury Michael Ramsey in 1966 as a Roman Catholic recognition of sacraments celebrated in the Anglican Communion. He continued, what does it mean when Pope Paul VI gave a chalice to the Archbishop of Canterbury? If it was to celebrate the Lord's Supper, the Eucharist, if it was meant to be done validly, no? This is stronger than the pectoral cross, because a chalice is not just used for drinking, but for celebrating the Eucharist. With these gestures, the Catholic Church already intuits, recognizes a validity. When Cardinal Coco Palmerio welcomed a revision of Pope Leo XIII's determination on Anglican orders, he also stated that the current situation is unclear. On the other hand, other changes occurred in the last quarter of the 20th century, making a reversal of apostolic et curiae virtually impossible, even if there were a change in policy. The ordination of women as priests and bishops in many churches of the Anglican Communion, but not in others. The significant shift in positions of moral theology in many churches, and such possibilities as lay presidency of the Eucharist are only a few of the issues that make a global statement or reevaluation of Anglican orders impossible, since factors which might be true for some people ordained, even within the same church, might not be true for others. The decree on the Eastern Catholic Churches, Orientalium Ecclesiarum, in 1964 from the Second Vatican Council, number 25, clearly stated that Eastern clerics, seeing that a valid priesthood is preserved among them, are permitted to exercise the orders they possess on joining the unity of the Catholic Church in accordance with the regulations established by the competent authority. And this statement forms the foundation of Canon 899 of the Code of Canons of the Eastern Churches, which reads, "A cleric of an Eastern non-Catholic church entering into full communion with the Catholic Church can exercise his sacred order in accord with the norms established by the competent authority. A bishop, however, cannot validly exercise the power of governance except with the assent of the Roman Pontiff, the head of the College of Bishops." Now, several significant points should be made concerning that canon, which has no counterpart in the previous canons, and whether promulgated or unpromulgated, of the Eastern Catholic Churches. First, the canon specifically restricts this provision to the clerics of Eastern non-Catholic churches. A previous draft spoke simply of Eastern clerics, but this was modified to more precisely identify the church of which the cleric had been a member, since the importance of the Oriental restriction, the Oriental characteristic, was principally a designation of the church rather than a personal characteristic of the cleric himself. The council and the canon make a positive statement about clerics. They are to be received into the Catholic Church in the order each one possesses, and they are entitled to exercise their respective order in accordance with the norms established by the competent authority. This means that their ordination will not be repeated, but that the competent authority will decide which office they should exercise in the Catholic Church. Second, this only related to clerics who were coming into full communion with the Catholic Church. The canon did not attempt to make a global statement about the orders or ministry of any or all non-Catholic churches, but rather attempted to assist in the integration in the most appropriate way of a cleric who, following his conscience, sought fuller communion with the Catholic Church. And third, the competent authority mentioned in Canon 899 would be the local hierarch in the case of clerics other than bishops, as well as the patriarch. And that was established in the previous canon, Canon 898, Section 2. The Congregation for the Doctrine of the Faith issued a decree on the 17th of September, 1976, which began with a recitation of the facts which brought that case to the congregation's attention. It read, His Excellency, the Most Reverend Pierre Martin Nodin Took, titular Archbishop of Regia, at midnight on the 31st of December 1975 in the village of Palmel de Troya, ordained priests contrary to the express prohibition of His Eminence, the Cardinal Archbishop of Seville, and without regard to the law contained in Canon 955 of the 1917 Code. Moreover, on the 11th of January 1976, contrary to the norm of Canon 953, without pontifical mandate, and what is more serious, without canonical provision, he ordained 5 bishops. Finally, the bishops who had been ordained in this manner, in their turn, carried out further priestly and episcopal ordinations, even in other places. The congregation provided, in addition to the excommunications and suspensions that were imposed on the bishop who carried out these ordinations and the men that he ordained, the following significant conclusion. Finally, the decree reads, as regards those who have been ordained in this unlawful manner, or who may in the future be ordained by them, whatever about the validity of their orders, the Church does not recognize their ordination, nor shall it do so. And she considers them as regards all legal effects in the state which each one had beforehand, and subject to the above-mentioned penal sanctions until they repent. The English translation, in a somewhat obscure fashion, of the Latin phrase quidquid este ordinum validitate, which might be more helpfully translated as whatever may be said about the validity of the orders. This decree explicitly refuses to make any statement at all about the validity or invalidity of the ordinations of the men ordained by the Archbishop, or of the men ordained by those who were thus irregularly ordained. It simply stated that these men could not be considered as clergy of the Catholic Church. And here the issue was not the ceremonies performed, the form of the liturgy used, or the intention of the minister. One might assume in those cases that the rubrics undoubtedly were scrupulously followed, and that it was certainly the intention of these men to ordain and be ordained as bishops, priests, or other clerics. And yet Cardinal Shepherd, in effect, refused to recognize these men as ordained ministers of the Catholic Church because they exercised their ministry outside the visible bonds of any church or ecclesial community, Catholic or non-Catholic. The main concern here is for the ecclesial reality within which the ordained exercise their orders. And while the CDF did not extend this statement to any non-Catholic bodies, it did at least raise the question of to what extent the ordinations of those who exercised ministry within their own communities and churches could be recognized. Here there is some clear ecclesial reality, even though it may in some sense be defective. As a point of reference, the genesis of the canon of priests and deacons ordained in churches in the historic succession, but not in communion with this church, of the Constitution and canons of the Protestant Episcopal Church in the United States of America may be considered. This canon was adopted by General Convention of the Episcopal Church in 1934 as a result of a particular, not to say peculiar, opportunity in the life of the Episcopal Church. The years immediately preceding the First World War saw the peak of immigration of Europeans to the United States. Many of these people were Roman Catholics, and in America, they were members of national parishes, established and largely supported by the hierarchies and governments of the countries from which they had come. The years following the war which resulted in major changes in the face of Europe, witnessed a sharp decrease in the financial and moral support for those parishes, and an increasing restlessness under pressures to conform to what was considered to be normal American Roman Catholic ways. In this period, a number of the clergy and laity of these national parishes sought membership in the Protestant Episcopal Church in the United States of America. And while many of these congregations were ultimately combined with neighboring Episcopal churches, a few still survive as active parishes. The Church of St. Anthony of Padua in Hackensack, New Jersey is one example. The picture on the slide is the interior, and that was taken in the 1950s, so about 40 years after it became an Episcopal church, an Anglican church, not what you would call kind of mainline Anglicanism, perhaps, but there it is. It was incorporated in 1914. It was founded as the Church of St. Anthony of Padua, as a Roman Catholic parish of the Archdiocese of Newark. In 1914, it became the independent National Roman Catholic Church of St. Anthony of Padua, and it was received into the Episcopal Church by the Bishop of Newark, Anglican Bishop of Newark, in 1925. And it's still a functioning parish. Under the direction, in 1907, a group of Italian-speaking parishioners in Youngstown, Ohio, formed the parish of St. Rocco, and as a part of St. Anthony's Roman Catholic Church in Youngstown. And they left the Catholic Church and joined the Episcopal Diocese of Ohio in 1918. And they were received into the Episcopal Church. And but in both the case of St. Anthony's in Hackensack and St. Rocco's in Youngstown, they kept their original buildings. Given what happened in the Episcopal Church in the 1970s, as congregations left but couldn't take their property with them, I wondered how that happened. What happened in both the cases of St. Anthony's and St. Rocco's, they took out major mortgages and loans beforehand. When they left the Catholic Church was no longer able to pay off those loans. They were repossessed by the bank and then were repurchased by the congregations from the bank outside of the after they had joined the Episcopal Church. So something of a subterfuge there. In 1957, a new church was built, which is on the right there for St. Rocco's. Dropping attendance led to the realization that the parish would have to close, and that parish did close in 2006. The building, oddly enough, is now a mosque. In these, as in all such cases, conformity with the doctrine, discipline, and worship of the Episcopal Church was required. There was a brief transitional period, being permitted to effect changes from the Latin Missal. And both of these churches, and at one point there were up to about 12 parishes, using the Book of Common Prayer in Italian. And so that was how those parishes, so at this point, the only one continuing to do that is St. Anthony's in Hackensack. Until 1961, the provisions for receiving deacons and priests into the Episcopal Church from other non-Anglican churches, or who had been ordained in the historic succession, was contained in a separate canon. And in the 19th century, that provision was very simple. Under the canon of 1841, practically all that was required of such a minister was, first, the production to the diocesan bishop of a certificate signed by 2 presbyters of the Episcopal Church, stating that his desire to leave his former communion was not because of any circumstance unfavorable to his moral or religious character, or such as to render it inexpedient to admit him to the ministry of the Episcopal Church. And second, he had to subscribe to the declaration set forth in Article 8 of the Constitution of the Episcopal Church, that he believes the scriptures of the Old and New Testaments to be the word of God and to contain all things necessary to salvation, and to solemnly engage to conform to the doctrine, discipline, and worship of the Episcopal Church. There is no reordination, and simply a declaration of admitting the person. The consent of the Standing Committee of the diocese was required, as well as the promise to submit in all things to the discipline of the church without recourse to any foreign jurisdiction, civil or ecclesiastical. It's to be noted that those ministers are not classified prior to their reception as postulants or candidates, but simply as applicants, and they remain as such for 6 months. Two conditional ordinations as Catholic priests of former American Episcopal clergy took place after the Second Vatican Council, each after extensive consultation with the Congregation for the Doctrine of the Faith. The first took place in 1978, the second in 1993. In each case, the ordinand was asked to provide the episcopal pedigree of the bishop who had ordained him to the presbyterate and to indicate the presence of Orthodox and Old Catholic bishops in those episcopal consecrations. These are conditional ordinations in the Roman Catholic Church. In the following year, Graham Leonard, the, at that point, former Bishop of London of the Church of England, was ordained conditionally to the priesthood in the Catholic Church. This ordination was noteworthy in at least 2 respects. Leonard was not required to undergo any ordination to the diaconate in the Catholic Church prior to his conditional ordination to the priesthood, and a special liturgical formula authorized by the Congregation for the Doctrine of the Faith was inserted into the ordination liturgy, giving thanks for the years of ministry of the ordinand outside of the Catholic Church. Basil Cardinal Hume, the ordaining prelate, issued the following as part of a statement at the time of Leonard's ordination. He said, after extensive research and careful consideration of the factors necessary for validity, the authorities in Rome instructed me to ordain Dr. Leonard to the priesthood conditionally, in accordance with the norms of Canon 845, Section 2. In such a case, during the course of the ordination liturgy, the Church prays that Almighty God will grant the candidate the grace of the Catholic priesthood, in case he has not received it through his ordination celebrated in the Anglican Communion. The liturgical formula was significant, not only because of its drawing explicit attention to the public ministry of the ordinand outside of the visible bonds of the Roman Catholic Church, but also because the formula was provided in a generic form. The name of the ordinand was given simply as nomen, and the thanksgiving was made for number, insert number here, years of faithful ministry, indicating that it was foreseen that this formula would be used in cases other than those of Graham Leonard. The actual formula I have in the handout. Whether or not this has in fact been the case is unknown, as publicity has not been given to this use by the press, and reports of subsequent conditional ordinations of former Anglican and Episcopal clergy remain anecdotal. Clergy who enter the personal ordinariates established under the Apostolic Constitution Anglicanorum Cedibus are routinely ordained absolutely. While there have been numerous clergy who have gone from Catholic to Protestant churches, as well as Protestant clergy who have been ordained in the Catholic Church, these have all been handled on a case-by-case basis. After the pastoral provision was established by John Paul II in the 1980s for former Episcopal clergy who wished to come into full communion with the Catholic Church, a special delegate, originally Bernard Cardinal Law, was established to process requests for ordination and the dispensation from celibacy where that was necessary. This formal process, including extensive testing and evaluation, was extended in some individual cases to non-Anglican clergy. When the personal ordinariates for former Anglicans were established a decade or so ago, the Congregation for the Doctrine of the Faith continued to study the dossiers of each individual former Anglican priest to determine his suitability for ordination in the Catholic Church. In neither the case of the pastoral provision nor the personal ordinariates was a blanket statement made about the validity or invalidity of the orders the applicant had previously received in his prior denomination. Repeated statements have been made highlighting that it is the general policy that all ordinations in the Catholic Church of former Anglicans are to be absolute and not conditional, although, as has been seen, there are exceptions to this as well. In recent years, there have been conversations between churches on the diocesan and supradiocesan level. The most notable of these is probably the agreement between the German Catholic Bishops' Conference and the Old Catholic Diocese of Germany in 1999. This document was referenced in a National Conference of Catholic Bishops press release on the 18th of April, 2011. And in particular, the members considered the agreement reached in 1999 between the German Catholic Bishops' Conference, this is from the press release, and the Old Catholic Diocese of Germany. They believe that this agreement offers wise counsel on this question to the leadership of their churches. The agreement is available in the German original with an unofficial English translation online. That's what it said. I have included the German in a footnote, and it took a certain amount of, what would the word be? A certain amount of ingenuity to find it, because that link is now dead, perhaps not perhaps not coincidentally. More specifically, the agreement calls for consultation between the bishops of both churches, which would be particularly useful in determining the individual clergyman's moral and psychological suitability for public ministry. It also provides that the clergyman, after the transition takes place, will not be assigned in the same region where he served in his previous church. The members are convinced that such cooperation will do much to reduce the problems caused by these transfers. And as I said, it may not be coincidental that the link in the press release, when an attempt was made to access the original document between the German Bishops' Conference and the Old Catholic Diocese of Germany, using that embedded link, was found to be dead. The origin of much of this may be the provision of Canon 844, Section 3 of the Code of Canon Law, for those other churches which in the judgment of the Apostolic See are in the same condition in regard to the sacraments as these Eastern churches. Thus far, the only church which has been so recognized is the Polish National Catholic Church, despite clever argumentation that Unitatis Redintegratio 13 constitutes such a recognition for the Anglican Communion. The United States Conference of Catholic Bishops press release is significant for a number of reasons. First, the argument or the agreement took place not at the level of the Universal Church, but at a lower level. Second, the agreement dealt with what might be called a transfer of clergy, providing the possibility of Roman Catholic clergy to become priests of the Old Catholic Church and vice versa. Whether this ever actually happened in practice is unknown. And third, the agreement would appear to be limited to Germany, although the press release was about the discussion between the USCCB and the Polish National Catholic Church in the United States, where, according to the press release, a similar agreement was being discussed. No canonical agreement has ever been published between the Catholic Church on any level and a Western non-Catholic church. The principal ways, thus, in which the Catholic Church has received clergy ordained in other non-Catholic churches are thus sanation, re-ordination, both conditional and absolute, and reception by a competent authority, in cases described by the Code of Canons of the Eastern Churches in Canon 899. In some cases, the provisions are motivated by policy, in others by historical circumstances. In recent history, provisions for receiving Western non-Catholic clergy without reordination have been negotiated on a regional level, but whether this is still an active option remains to be seen. Thank you.
Thank you, Becket. What a fascinating tour of this topic: historical, ecumenical, canonical. So many things to think about. Really appreciate the presentation. We've got time for some questions, which you've kindly said you're happy to answer. So what I'm going to do is just allow it so that people can unmute when called. If people want to ask questions, you can either type something in the chat or find, I think it's under reactions, the raise hand button. But I noticed we've had a couple of questions posted in the chat already. Adrian, would you like to ask your question that you posted?
Yes, thank you. It's just when Father Becket was talking about radical sanation, it reminded me that there was a case, it was an American Roman Catholic priest who was in the news recently, who had made a mistake in baptizing loads of people over about 10 years using the wrong formula of words. And I think he had to then trace all these people to try and then they had to go through the ceremony again. And it made me think, well, why didn't the Catholic Church use the radical sanation, dispensation? Would have been a lot easier.
I think that the reason that was given for that is because it was the form of the form that was used was not a valid form, so that the difficulty there was not a legal one, because sanation is ultimately a legal response, but that it doesn't answer the theological question of whether or not that was valid. So I think that's why they had to track down everybody who had been everyone who had been baptized, and that has happened not just in that one case, which I think was in Chicago or in the Midwest, but a number of other dioceses in the United States have done that, and in each case there has to be because of the theological problem, and not so much because of the legal problem of the defect.
Thank you, Becket, and thank you for your question, Adrian. We also had in the chat a question from Ashok. Would you like to ask that question?
Yes, it relates to transgender. What is the Roman Catholic position on a priest, either say an Anglican priest or Roman Catholic priest, who is a male at the time of ordination, who then becomes a female in England by virtue of a gender recognition certificate under the Gender Recognition Act 2004. I'm sure there's an equivalent statute in Canada. Does that person then cease to be eligible for priesthood in the Roman Catholic Church?
Yes, Well, I mean, what happened? I've actually done laicization cases for 2 of these. What happens is that the person the person's dossier is sent to Rome for laicization, and in both cases, it was granted. The laicization was granted favorably, and by return mail. So that is the typical way that happens, because I know that there are more than 2, but those are the 2 that I have worked on, of those who have undergone whatever name you want to give it, whether it is sex reassignment or something like that, so that if they have already been ordained, then they would be laicized, and if they have not been ordained, that would be that would be considered an irregularity for the reception of orders.
Thank you for that question. Another question in the chat. Ted, would you like to put your point? We can't hear. I think we can't hear you, Ted. I can't hear you anyway. I'm not sure if anyone else can. You are unmuted, but I can't hear you. Shall I read it out? Sorry that we can't hear you. The question was, I think it was referring to the sanation of baptism or otherwise. Does the question of the defect have to do with human law versus divine law? That is, the church cannot sanate something which is above its pay grade.
Yes, well, I mean that is you know, that is certainly part of it, and that that which is part of the church's positive law. So in the case, for example, of sanation of a marriage, to use something that happens far more frequently, in the case of the sanation of a marriage, if there is an impediment, the impediment either has to cease or it has to be dispensable, and thus a natural law impediment. If that were present, that marriage could not be sanated unless the impediment ceased.
Thank you. No, do we have any other questions? Do feel free, if you rather just ask the question, to raise a hand. John, I can't see you on the screen, but ask away.
Thank you. Becket, thank you so much. Absolutely fascinating. My question is really rather mundane, except it's quite revealing in my experience. In England, a former Roman Catholic priest, having been received into the Church of England, until, well, having been in Australia and now retired, I don't know what the current situation is, but certainly when I was a bishop in England before going to Australia, the Archbishop had to give consent to the granting of a license for such a priest under what was known as the candidates ordained abroad measure. Now, that was instituted in the early 90s when there were some parts of the Anglican Communion who had introduced women bishops and others hadn't. And it was to do with checking on who had actually ordained that person. And Roman Catholics were put under that same heading. So it was just to check that there was a valid ordination. I don't know whether that still happens, which is an interesting question. But then when I went to Australia, all we had to do there was get from the former ordinary, from the priest's previous ordinary, a letter that the priest was in good standing. Now, of course, it seemed to me that a Roman Catholic bishop, in fact, I got a letter saying exactly this, couldn't say that this priest was in good standing because he had left communion in the Roman Catholic Church in order to get married.
Yes.
And there is a really difficult then piece of interpretation in terms of the different ways of describing things between different communions. And you have to read a letter in a particular way. And that, you know, actually the Archbishop in Australia was really quite iffy about it. And I said, no, this is not, he can't say he's safe to, he's in good standing because he's not. I mean, just a kind of comment about the complexity of all of that.
Well, I mean, to some extent, referring to my own situation, which takes that to another level of complexity, perhaps. When I was ordained in the Catholic Church, I was still a priest in good standing in the Episcopal Church in the Diocese of North Carolina. And so I was actually on the clergy list of two churches simultaneously, as a kind of a valid, priest, though I served in a parish in Romford in Essex in the 1980s. In order to get the license from the Archbishop of Canterbury, who at that point was Robert Runcie, I had to go down to Lambeth Palace, where I was given a very, very fancy looking piece of paper and signed on the back by the registrar in a completely illegible signature. But the Archbishop signed using a biro and on the front, and then he invited me to tea. And I asked when I got back, why did I need to do that? And they said, oh, they just, because it said it was because of the Overseas and Other Clergy Act, being an American, but, and they said, oh, they just want to make sure that you're not a woman. And so that was, I mean, that's, again, completely anecdotal, but the way that this thing plays out certainly in the Episcopal Church, with Catholic clergy coming into the Episcopal Church, they are simply received, so not as candidates or postulants, but simply as applicants, so that they are, in the period before they are recognized, they are kind of neither clergy nor lay, and that is neither fish nor fowl.
Thank you.
Yeah.
Thanks for your question, John. Do we have any other points or questions? Just rising from that, it's perhaps unfair, Becket, to ask you a question about Episcopalian ecclesiastical law, but I did wonder, when you mentioned Catholic priests becoming Anglican priests, how, if at all, is their vow of celibacy dispensed?
Well, it's simply with first off, it's a promise. I mean, in assuming that they are not religious. So religious do take, some religious take vows of chastity, but it's a promise in ordination, and presumably the promise does not bind if it is no longer possible to keep it. And so I don't think that is, I do not know that is a question that has been addressed, certainly in the Episcopal Church. I do not know with others, what happens with others. But I think that, certainly they have married, and in most cases, but not all. So I do not know whether that even is taken into account.
Sure. Oh, thank you. Thank you. We do have to draw to a close quite soon. If there's anybody sitting with a burning question or issue, we could take it. But otherwise, I do want to say again, Becket, how much and I'm sure everyone here really appreciates what you've had to say. It's been such an interesting and wide-ranging tour. As an Anglican, of course, my focus on this question is as for many Anglicans, apostolic curiae and what it has to say. And I think you're placing it in that broader historical context, both antecedents and the more modern context, really helps to explain and to understand the issues much more broadly. And the focus that you drew our attention to on ecclesial reality in thinking nowadays has really helped, assisted me in understanding. So appreciate that very much. A good night, a good day to everyone.